Congratulations to both of you. Judge, let me start with you. What's the difference in your mind between an originalist and a textualist?
So in my mind, I think that they're strains of the same idea, largely. My understanding is mostly that people talk about textualism in reference to statutes and originalism in reference to the Constitution, but both of them are rooted in the idea that the words of the enactment from the political bodies should govern application of the law and should be the starting point.
What do you do, Judge, in a circumstance where the drafters of the where the drafters of the Constitution and or the Bill of Rights, but also the people, it's what people thought then that matters, whether they could not possibly contemplate a situation before the court, and therefore there would be no plain meaning because the drafters couldn't possibly contemplate it.
So I think the situation that you're describing is not uncommon, and it's a difficult situation.
Yeah, what do you do?
So you look, in my mind, you go through that analysis of what did these words mean when they were enacted, what do people think they mean, and you try to glean from that the principle, the governing idea, and apply that to new circumstances.
But how could you if the drafters and the people reading the original document couldn't possibly imagine it?
So a difference between the Constitution and statutes is that a Constitution is a charter document. It states broad principles as opposed to addressing more specific or discrete issues like statutes do. So again, I think you're looking for those guiding principles, those foundational ideas that form the country or the structure of our government, and figuring out how to apply them to modern circumstances. It's not an easy task, but I think it is important that we stick with what our understanding was of the formation of our government when we started.
Okay. Are you familiar with the Holy Trinity doctrine?
I have heard of that doctrine. I don't remember.
It's an old case. I think it was in the late 1800s. It was a Supreme Court case. Basically, there was an immigration statute the U.S. Supreme Court was construing, again, in the late 1800s. I think the text of the statute was pretty clear. And the Supreme Court said, look, the statute's pretty clear, but we want to have belt and suspenders. So we're going to take a look at what the Congress thought as well. And we're going to look at the legislative history just to be sure, and we're going to try to understand the policy behind the statute. We're not going to ignore the plain meaning, but we just want to be sure. What's wrong with that?
So I'm not sure that there's anything wrong with that. I guess I would say that the difficulty comes in, or the problem comes in my mind, when you're looking at legislative history and it might lead you to a place other than where the plain language would lead you. So as I've said before, in my view and how I would approach analyzing law is to start with those words, figure out what they mean based on their plain language, based on context and structure, based on the canons of interpretation. And certainly legislative history can inform in certain circumstances. My hesitation with that whole area, however, is as a practicing lawyer, I have seen how easy it is to cherry pick things in the legislative history that work for you and ignore things that don't work for you.
Valid point. Let me move to the professor here. I'm going to call you professor because you used to teach. Professor, we have this rule that the judiciary has adopted. You strive to construe statutes to avoid constitutional issues.
Yes.
Why? Isn't that what you guys are paid for? I mean, why does that make sense? I've always wondered. I'd like your thoughts on that.
So I think the Supreme Court has addressed this in a number of cases, and I think it boils down to respect for the legislature. I think it boils down to separation of powers and the respect that each branch of government owes to each other. And the idea, I think, that underlies that is fundamentally one of judicial self-restraint, that if there is a construction that can be given to a statute that is consistent with the Constitution, it is more respectful to Congress for the judiciary to give that construction to it, rather than to imagine that it means something contrary to the Constitution and to strike it down. So I think fundamentally, it's about respect for the co-equal powers of the Congress.
Okay. Thank you both. Thank you, Mr. Chairman.
Thank you.